Hello, my name is Yanjun. In this video, I'm going to tell you about the judicial corruption in Singapore. My intention is to ensure that every public official, including the founding father of Singapore, the late Prime Minister Lee Kuan Yew, is subjected to the rule of law. Here, the judicial corruption refers to the Supreme Court's bias in favor of the Singapore government. I understand that Singapore has a reputation for absence of corruption, so I will present solid evidence to back my claim. On the 3rd of November 2015, I reported the evidence to Prime Minister Lee Hsien Loong by email and requested for investigations. A large number of local and international organizations were copied in on this email. On the 30th of November, the Attorneys General's Chambers, the AGC, replied in their email at paragraph 3 that in your emails, you have alleged that the Supreme Court was biased in favor of the government when they heard the suit. These allegations are spurious. And at paragraph 6, that your unfounded allegations of bias on the part of the Supreme Court are in contempt of court, and you are thereby warned that if you continue to make these allegations, contempt proceedings can be brought against you. 4 days later, I wrote to the Prime Minister for the 3rd time to stand by my corruption allegations, but the AGC did not take any action against me. So I have enough reason to believe the government is covering up its misdeed. It seems to me that posting a video on the web is the only way to get the message across to the general public, and that explains why you are watching this video. This video is divided into 3 parts. In the first, I will present evidence of judicial corruption. In the second part, I will explain briefly why Singapore has done well in international anti-corruption surveys. The third part is my conclusion. Part 1, evidence of judicial corruption. The former chair of Transparency International stated in 2007 that judicial corruption means the voice of the innocent goes unheard, while the guilty act with impunity. For laymen, it is safe to see judicial corruption equals to a judge's or court's bias towards party. My evidence of judicial corruption is actual bias displayed by the Supreme Court in a police wrongful arrest case. In this confirmed wrongful arrest case, the Supreme Court punished the victim, or me, and awarded the police in order to cover up a huge mistake made by late Prime Minister Lee Kuan Yew in interpreting the Constitution of Singapore back in 1984. It is this unjust decision that clearly demonstrates the Supreme Court's bias in favor of the government, or the judicial corruption in the Supreme Court. Now I'm going to tell you how this case came about and the critical issues of this case. On the 19th of July, 2009, I called the police for assistance, but in my flat, the 2 police officers refused to take my report, but instead arrested me for an offense of breach of personal protection order, or PPO. I was detained in police division overnight and was released on bail the next day. From arrest to release, I was not taken before court to examine whether there were reason for the police to arrest me. But the PPO was later discovered to have expired some 2 weeks before arrest. While arrest was found to be unlawful, the AGC insisted that the arrest was lawful in response to my complaint filed in 2012. On the 1st of April 2013, I brought a suit against the police in the Supreme Court. Put it simply, the case mainly concerned with 2 issues. The first is whether the arrest was lawful. The second is whether I should be taken before court to examine whether there are reasonable grounds for this arrest. The Supreme Court encountered great difficulty in answering the second question because the international community and the late Prime Minister have totally different answers. The United Nations recognizes that an arrested person is entitled to be brought before court within a certain period of time, usually 48 hours after arrest, so the court can decide on a lawfulness of arrest and order his release if the detention is not lawful. This 48 hours is meant to provide the police with sufficient time to overcome delays in order to bring an arrested person before the court. However, the late Prime Minister took the 48 hours as sufficient time for police investigation in order to take further action against an arrested person, and as a result, the lawfulness of the arrest hasn't been examined by the court since 1984. The following is the late Prime Minister's reasoning behind the 1984 amendments to the Constitution. The amendment is necessary to enable the police to investigate offences more thoroughly. By extending the limit to 48 hours, the police will be in a better position to complete their investigations and to carry out follow-up action. It is a fact that Singapore has subscribed to the Universal Declaration of Human Rights prepared by the United Nations. But it should note that the late Prime Minister's erroneous interpretation has not only contradicted the international law, but also violated the principle of presumption of innocence. On the 25th of August, Minister for Law expressly stated in the Parliament that the government is absolutely committed to upholding the presumption of innocence as a core principle in our commitment to the rule of law. Now I'll tell you how the judicial corruption is involved. The case was heard 3 times, and on the 27th of November 2014, the Court of Appeal, or the highest court, finally ruled that the arrest was unlawful, and the late Prime Minister's interpretation of the Constitution was correct. Shortly after the release of the final judgment, I criticized it by proving the late PM's interpretation wrong, but the Supreme Court declined to respond to my criticism by saying, "Please be informed that the contents of the email and the attachment has been placed before the court. The court will not be responding to the comments found in the attachment." And even worse, the Supreme Court even refused to admit the final judgment was correct, but required me to comply with it. In response, I refused to attend subsequent hearings in order not to comply with the final judgment voluntarily. In this situation, the Supreme Court issued an order on 11th of June 2015 to press me to attend the hearings. Otherwise, the entire case would be dismissed. I still refused to attend the hearing. So, on the 9th of July, the Supreme Court dismissed the entire case and ordered me to pay legal fees to the police. This is how the Supreme Court's most unusual decision to punish the victim and to award the perpetrator came about. When questioned why not to punish the police for making the wrongful arrest, the Supreme Court answered on the 15th of September that the lawfulness of arrest is an issue which was supposed to be decided at a future trial. In the agency's letter dated 9th of October at paragraph 4, the State Council refused to explain how to breach an expired PPO, but treated the arrest as lawful by saying, "As you are aware, our position is that there was no police misconduct." So it is safe for me to question the integrity of both the Supreme Court and the agency. There are 3 types of corruption: petty and grand. Petty judicial corruption usually refers to bribery, and the grand corruption involves the highest levels of government. Since the Chief Justice was aware of this matter but did not intervene, it is safe for me to conclude that the judicial corruption in the Supreme Court falls into a category of grand corruption. This is the end of part 1. Part 2. Why has Singapore done well in international anti-corruption surveys? I think there are 4 reasons. The first reason is the limited freedom of expression due to tightly regulated press and media. The second reason is the plaintiff-friendly defamation law, so even the international press prefers not to mess with Singapore. The third reason is most rankings, such as Corruption Perceptions Index prepared by Transparency International, is perception-based. In other words, it doesn't reflect how uncorrupt Singapore is, but how uncorrupt the general public think Singapore is. Fourth, the Singapore government did make serious efforts to bring endemic petty corruption under control. So finally, my conclusion is that Singapore's reputation for absence of corruption is an artifact, and Singapore's experience in fighting corruption is unlikely to be copied in other countries due to a lack of grand judicial corruption. Thank you.